Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. All right, Jeff, welcome back, and congratulations. You have just had a case handed down at the Supreme Court, and you prevailed. So again, congratulations. Let's talk about that today.
Well, I'll be happy to talk about it. Yes, we prevailed in part and lost in part, but prevailed on the part of the claim that I was hoping that we would prevail on.
Right. And I believe in a previous podcast, we mentioned that at the time you had roughly 4 different cases in front of the Kentucky Supreme Court, and this is the first of those to be kind of wrapped up. And so let's talk about this. What kind of case was it? For a case to go all the way to Kentucky Supreme Court, there had to be some serious issues there.
It was. There were some significant issues in the case. It seemed to kind of grow as the case went on, to be honest. It was an unusual set of facts for a workers' compensation claim in Kentucky. The gentleman was injured. He was a sheriff's deputy, and it was actually was reported about in the Murray Ledger and Times. So he was a sheriff's deputy involved in a significant motor vehicle accident on the job back in 2007. He had a local attorney, but not myself, but a different attorney, Mr. Michael Pittman, who handled his claim back then. That claim was resolved. The claim was reopened in 2013 because of some increased issues and some increased disability the gentleman had, Mr. Spillman, and that claim was resolved as well. I think that one went to a judge's decision, if I'm not mistaken. But unfortunately, Mr. Spillman had to have surgery in January of 2017 as a result of the work-related back injury that he had suffered and had complications, and then passed away shortly after that surgery took place.
And under Kentucky law, that's the interesting thing, that at least in previous years regarding workers' comp, is that there is an ability to reopen the case if there are further complications. And that's different than a civil case. That's different from a normal personal injury case. But because this happened to Mr. Spillman on the job, he has this right under Kentucky workers' compensation law, correct?
Yes. In the law at the time of his injury, he had the right to reopen the case within 4 years of any previous judge's order on that case, which is what had happened. The injury was in 2007. I think he had originally resolved in 2010. He reopened in 2013, which was 4 years within the 2010 resolution. That resolved later on in 2013. And then, unfortunately, he passed away in early 2017 as a result of the work-related injury and the medical treatment for the work-related injury. And his spouse and the estate then had potential claims at that point in time. And that's when I become involved in the case. Mr. Pittman contacted me and asked if I would help him out on the claim at that point in time.
And that's actually not uncommon. I mean, this is called co-counseling, and you've probably brought in co-counsel in cases, and you've been asked to come in as co-counsel because you may have a certain area of experience that you understand this area or facet of the law, and it just helps to really have another pair of eyes on the case, right?
That's correct, yes. And frequently I'm asked to co-counsel with other attorneys on cases, and then there are certain cases that I will ask other attorneys to co-counsel with me on those cases as well, because having 2 sets of eyes in 2 sets of hands, or more than 1 set of hands working on a case, can be beneficial to the clients in that setting. Sometimes they have greater experience in handling this type of case or that type of case, whatever the case may be. From that standpoint, sometimes you bring someone in because they have or an attorney brings another firm in because they have the financial resources to pursue that type of claim, and the original attorney may not have those type of resources.
And in this situation, in 2018, when the workers' compensation law was updated, was that at the point where there was a change in the law that affected this case specifically? Is that what brought you into this case?
Well, no, I was brought into the case in 2017.
That's right.
Before
Okay.
the law
Yeah.
come in. I was brought in because of it was going to be some complicated facts in the case there, and basically there was some issues under the law as to how you would pursue the claim, whether you would pursue it as a reopening of the original claim, or whether the surviving spouse and the estate had their own independent claim that they could pursue. At first, when we did this, I didn't know that it's going to make that much of a difference. Ultimately, that turned out to be the biggest factor in the case for the surviving spouse, because they did change the law on reopening in 2018. But what we did is in September of 2017, I filed a motion to reopen, but I also filed a new claim form, which I thought was the appropriate avenue to go with the new claim forms. But the Department of Workers' Claims electronic filing system really wasn't set up for that, for the surviving spouse to file new claim forms. And in fact, they called me up afterwards, after I filed it, and said, you shouldn't be filing this on behalf of the surviving spouse. And I said, at least I told him, I think this is the appropriate way to pursue the claim. And so, they filed it the way I had asked, as well as the motion to reopen.
You safeguarded their interest either way.
Exactly. That's exactly what I was doing. And at the time, there wasn't any problem with the motion to reopen. There wasn't a time issue there. We filed it within 4 years of the 2013 award that come out in October of 2013. So we were before that 4-year window would have expired on us. In 2018, July 14, 2018, actually, they changed the law on reopening to say it's 4 years from the date of the injury, or 4 years from the first opinion or first decision in that case. So and said that applies to all pending cases. So that would have, if it was a reopening, that new law in 2018 would have eliminated the case for their surviving spouse.
Well, not only for that case, but all subsequent cases that are out in the Kentucky Workers' Comp system now. All these other claims. I mean, that decision in 2018 really kind of shortcutted a lot of things and cut some people off at the knees in terms of their ability to reopen cases or to seek additional help.
Absolutely, it did, and it was, obviously, I didn't agree with the change in the law, and certainly didn't agree with applying it to cases that were already pending when the law came into effect. Because when we filed the motion to reopen in this claim, it was timely filed. It was filed appropriately, right. And then for the legislature to turn around nearly a year later and say, "Oh, we're going to change the rules of the game on you now," and after myself and Mr. Pittman had spent a significant amount of time working on this case, and then turn around and say, "Oh, we're going to basically cut the legs out from under you and have your case dismissed because we're going to change the rules."
Yeah, which just doesn't even feel right that should be possible. But again, that's why you have experienced attorneys such as yourself involved in these cases, and that's why some of your cases are ending up at the Supreme Court. You're fighting not only the technicalities, but also, hey, wait a minute, what is this really supposed to be doing?
Yes, and that's in this case, of course, the other side didn't even argue to start with. Didn't care if we filed a reopening new application. They didn't even raise that as an issue until the 2018 bill started being talked about, and a bill was filed actually in the legislature here in Kentucky that talked about changing reopening, and then the insurance company started taking the position, well, the proper avenue is a reopening, and this new law is going to take effect on this, and so that's going to prohibit this claim. So that really, the legislature basically created that issue for this case.
Right. And when a case is decided finally at the Supreme Court, in the legal system, at least in the U.S. legal system, it's based on precedent. So if there's already been a decision, that you kind of go back to that decision, what's already been done. So in essence, have you kind of made law here in for the state of Kentucky and on this issue?
Yes, on the issue, and what because earlier I said I won on part and I didn't win on another part, or lost on another part. The statute in Kentucky provides benefits to a surviving to survivors. It can be the surviving spouse. It can be minor children, or anyone who is dependent on the deceased worker for a work-related death, and those benefits are paid out based on a certain percentage of what the average weekly wage is of the injured worker, depending on if it's a spouse, a child, or
Right.
whatever.
Right.
From that standpoint, there's also another provision in that same section of the statute that says that if the death is within 4 years of the work injury, then the estate can get a lump sum death benefit. And that was the other portion of this claim: was, does the surviving spouse get benefits, and does the estate get a benefit? In the law, the statute clearly says 4 years from the date. So under the statute, they were not entitled. The estate was not entitled to receive the lump sum death benefit. I had challenged that statute on constitutional grounds. I knew that it was an uphill battle to try to have that statute declared unconstitutional. I thought I had a strong argument, and it took Supreme Court about 40 pages to rule against me on that. But we did lose on that issue there, but we won on I think the more important issue, and that is that the survivors now are going to be able to get the benefit. When we lost at that issue at the administrative law judge level, the administrative law judge had ruled that 4-year window applied to the surviving spouse's claim as well as the estate's claim. We appealed that up to the board. The board agreed with me that the 4-year window was only on the estate's claim and not on the survivor's benefits claim. And then the insurance company took the case up to the Court of Appeals because I probably would not have appealed the constitutional issue to the Court of Appeals, but since they did, I cross-appealed on that issue. We won on the surviving spouses issues at the Court of Appeals, lost on the constitutional question. They again appealed it up to the Supreme Court, so I cross-appealed again. If they hadn't appealed to the Supreme Court, I probably would not have appealed the constitutional issue, because even though I think I had a good argument there, and I wish I had one on that argument. I kind of saw where the handwriting on the wall was on that. So
Right. But I mean, the interesting thing is now going forward for cases that are currently pending and for future cases, your argument, which was ultimately successful at the Supreme Court, at least that one portion of it, is now what all these future cases are going to be. They're able to cite that case as part of their reasoning and rationale for their arguments on behalf of their clients as well.
Exactly, and it's going to be. I think it's going to have a major impact on the working families in Kentucky. That because, frankly, in this case is a prime example of that from that standpoint. If Mr. Spillman had passed away within 4 years of the accident, or he had passed away 10 years after the accident, as he did, the loss to the survivors is the exact same. From there, the loss of that earning capacity is the same there. And while workers' comp does not compensate for a loss of consortium type claims, doesn't compensate for pain and suffering and the grieving type damages, it is designed to replace the lost income, and that lost income is still there whether the person's death is shortly after the work injury, or the death is immediate, or whether the death is 15, 20 years later. That loss of income for the family is still there, and so this is going to allow other survivors, spouses, and dependents to be able to access those benefits when that occurs.
Fantastic. I mean, that's going to be a safety net for a lot of people.
Correct.
Which is outstanding work. Congratulations on that, and we've got 3 more up there. So, I hope we repeat this kind of an episode.
Yeah.
Let me kind of get into a little bit of inside baseball here. You've got now 2 attorneys working on this, or 2 separate firms working on this, and in a lot of cases, people are worried about attorneys' fees and how much is going to this person. How much because Mr. Pittman called you in, do I have to pay 2 different attorneys? How does that work?
That is well, To be honest, it kind of depends. If the attorneys are working on a contingency fee basis, which is what Mr. Pittman and I were working on this case.
Meaning it wasn't hourly. There's no, it's just, hey, we have to win to get paid.
Exactly, and the fee is a percentage of what the recovery is. If Mr. Pittman had handled the claim on his own and never brought me in, the percentage on the attorney fee would have been the exact same as if the surviving spouse had come to me instead of going to Mr. Pittman, and was the exact same with Mr. Pittman and I both working on the claim. It's the same percentage of the recovery. What happens is the attorneys, when we're co-counseling on the case, we will divide that percentage of the fee, whatever the fee ultimately comes out to, we'll divide that among ourselves based on the work each of us have put into the case.
Right. So it doesn't cost the family. It doesn't cost the injured person. It doesn't cost the estate anything else to, if someone decides to co-counsel, that's not the issue. That's kind of capped at a certain percentage and a certain dollar amount anyway.
Right. Under workers' comp, there is
Yeah.
a cap on that. In like car wreck cases and others, that there are there's not really a cap on the attorney fee, but the percentages, car wreck case I handle on a 1/3 contingency basis, and if somebody joins with me that already has the case that's got it signed up on a 1/3 contingency, it's not 1/3 to that attorney and 1/3 to me, so you're paying 2/3 in attorney fees. It's just that 1/3 attorney fee, and then whatever that
You
third
guys will settle
amounts
up on the
to.
back end.
Yes,
Yeah.
then we split that up based on how we worked on the case. When I said it depends earlier, and you mentioned our hourly rate, that's where it would make a difference. Is if the attorneys are working on an hourly rate, then whatever hours they spend, that attorney's getting paid their hourly rate, the other attorney's getting paid their hourly rate. So you're incurring attorney fees at both places in that setting, but it's also based on the work they're doing. So if attorney A working on the hourly rate didn't do that work, then the other attorney was going to have to do it. So you're really not increasing your fees any there, but it's a little different than the
Right. Depends on the
contingency
type
fee.
of case it is. At business law, where you've got multiple attorneys working on different things, or commercial real estate type laws and stuff like that, that's a separate issue. But all of this injury is done on a contingency here in Kentucky. So from that standpoint, it's a percentage and it's capped and it's in the contract and it doesn't cost the family or the
Yeah.
victim or the estate anymore.
Absolutely. And 99% of what I do in my private practice is on a contingency fee basis. It's, most of my clients could not afford to pay an hourly rate. And that's the benefit of the contingency fee is it keeps the courthouse doors open to everybody in the United States. It's not just the rich or the well off that can afford to have an attorney and go to court. With the contingency fee, that allows anyone to be able to obtain an attorney and to pursue a claim.
And that's a huge advantage to our system here. As far as workers' comp goes, now this was a case that went literally all the way up to the Supreme Court. We may have covered this in a previous episode, but could you kind of walk us through how does a case ultimately get there? You file it locally, you'll file it at the Department of Workers' Comp, and then kind of walk us through that timeline, if you will.
I will. In this case, basically, the portion that I was involved in took 3 years to get a Supreme Court decision, nearly to the day. We filed
Wow.
it in late September of 2017. The Supreme Court issued their decision September 24th, 2020. Uh, but the process with a workers' compensation claim, it's an administrative process to start with. So it's not a jury trial. You don't go to court here in Calloway County.
This isn't
Uh,
what you see on TV. This isn't CSI and all those kind of things.
Exactly. It is the case is initially tried to an administrative law judge, and the majority of it is basically on paper. We can file medical records and take depositions, but we just file the written transcripts of the depositions in front of the judge, and then the case would have a final hearing where only one or two witnesses actually testify, the injured worker and maybe a family member. That's not real common, but it does occur. A representative from the defendant may testify at the final hearing, and then the case goes to the administrative law judge to make a decision, not a judge or not a jury, I mean, and any party that is that doesn't like that judge's decision can appeal it. Now you're supposed to have a legitimate legal basis to
Right.
appeal,
Right.
obviously. So just because I lost and I didn't want to lose is not a basis to appeal. But an appeal can be made of the administrative law judge's decision, and that goes to the Workers' Compensation Board, which is a three-member, three-attorney panel. It's the same three on every case. There's only three on the workers' comp board, and they hear all of the appeals from the administrative law judges in workers' compensation cases, and that's all they hear are workers' compensation appeals. They don't decide anything but workers' compensation issues there, and that's the first appellate level, but it's still at the administrative level.
And they're looking for a misapplication of a law, or are they looking at some facts that weren't considered? I mean, is that what they're really kind of looking at?
Yeah, they're looking at the board level. They're looking at, did the judge commit an error of law, or did the judge commit an error uh, in assessing or understanding the facts? So if a judge completely overlooked some testimony in a case, there was a doctor's deposition that was taken, and the judge didn't make any mention that he ever reviewed that deposition or knew that doctor had testified, and it was filed into evidence in making his written decision in the case, then they would look at that and say, well, the parties are entitled to have the judge consider all of the evidence
Not
in
selective
making the
evidence.
decision, and then send it back for that judge to make a new decision based on all of the evidence in that case. So, in essentially, it's from a legal standpoint, the standard is the judge's factual determination supported by substantial evidence, and it's not a real. The judge doesn't have a real high burden to get to substantial evidence, but if they overlook evidence or something of that nature, then that would be a basis for the workers' comp board to reverse and send it back to the judge. The workers' comp board would not redecide the case. They send it back to the judge to correct whatever errors they feel the judge had made in the case. At that level, once the workers' comp board renders a decision, if they remand it back to the judge, then the parties can let it go back to the judge and make a new decision in the case, or whichever side doesn't think it ought to go back to the judge can appeal it to the Court of Appeals.
So this would be the second appeal, basically.
The second appeal, and then the Court of Appeals is their standards are a little different. They're basically looking at did the Workers' Compensation Board commit an error of law in the way they assessed their appeal, or did the decision somehow result in gross misjustice? And so it's an even higher standard to try to win at the Court of Appeals level. From that standpoint, again, when the Court of Appeals renders the decision, if they can remand it back to the administrative law judge and say, they can say the workers' comp board never should have remanded it. The administrative law judge's original decision would stand as it should stand as the way it was originally written. They
So
can
they're basically
say
overruling the board at that point.
overruling the board at that point. They can say the workers' comp board was correct in what they decided and in remanding it, and they can say that that they were incorrect in on the why they remanded, but there was an error, and this is the error, and so
Which could be totally different.
it could be totally different.
Wow. Okay.
From that standpoint, and so then they can say it needs to go back to the administrative law judge
And
to
this is the
address
same
these errors.
judge with whom you started.
Same
Yeah.
judge with
Yeah.
whom you started, and then again the parties can, if they don't like the Court of Appeals decision, then they can appeal it up to the Kentucky Supreme Court, which is the third level of appeal in the case. And really, most cases only have two levels. You have appeal to the Court of Appeals or appeal to the Supreme Court. Now, the district court decisions actually have a third level too, because they're appealed initially to the circuit court. From that standpoint, but the the workers' comp claims are, and part of the process is to elect with the workers' comp board is to try to keep it from overwhelming the appellate courts, the Court of Appeals and the Supreme Court.
Now, with other cases that we hear about in the news, the Supreme Court can decide whether or not they want to hear the case, whether or not they want to take it up. In the workers' comp system, if a case goes from the appeals board, from the appellate court, and one of the parties decides, no, we're going to take this all the way up. So they're going to go to the Kentucky Supreme Court. Can the Supreme Court refuse to hear the case or the claim?
No, not in a workers' compensation claim. The Kentucky Constitution says that a party is entitled to at least one appeal, and that's the reason you can go up to, as a general rule, you can go to the Court of Appeals in a case, and then you have to ask for discretionary review, a motion for discretionary review in the Supreme Court, which the Supreme Court could grant or deny. It's a motion for discretionary review in Kentucky. You hear a lot about it at the U.S. Supreme Court. It's a petition for certiorari at the Supreme Court, or U.S. Supreme Court. So those are where the court looks at it and says, okay, yeah, we're going to grant the appeal to come up to us or not in that setting. But the Constitution in Kentucky says you get one appeal from a lower court as a matter of right. Well, because workers' comp is an administrative process, the actual first court decision, as court is defined, at least under the Kentucky Constitution and statutes, is the Court of Appeals decision. So we have what's called a matter of right appeal to the Supreme Court in that setting.
So if you want to push it all the way, you possibly can get there.
Yes.
But it's going to take some time.
It's going to take some time. And on a workers' comp claim, the Supreme Court cannot deny hearing the case on appeal. They can obviously deny the appeal on the merits of the case, but they can't say we're not even going to consider that appeal. They have to take the appeal.
And because this takes a significant amount of time from the initial injury, working through the process, we're getting to maximum medical improvement, getting to a hearing, the first judge, making that decision, and then the board, and then the appellate level, and then finally the U.S. Supreme Court. How do you have that conversation with your clients? I mean, obviously it's ongoing throughout the case as it progresses, but at some point, do they decide it's, maybe we don't want to go through this, or it's got to be a delicate conversation?
Well, it is, and you get some frustrated clients at times there, but you help to dull that effect by explaining the process to them as you're going through that process. And, I tried to do that with every one of my workers' compensation clients and other clients for that matter in different types of cases is, this is how this process works. The first decision is administrative law judge decision. If we don't like it, we get to appeal that decision. If they don't like it, they get to appeal that decision. And at that appeal, if we don't like it, we can appeal. If they don't like it, the workers' comp board decision, they can appeal. And most of the time, if I'm appealing the case as a general rule, either I've lost completely, or at least I didn't get everything that I thought my client should get in the case. And so when I file the appeal, my client is, I'm telling them we're filing this appeal because I think the judge didn't give us as much money as we should have gotten in this case, or we didn't get an award when we should have. Like in the Spillman case, where the original judge said the spouse's claim was terminated at 4 years, and I didn't think that was correct application of the law. So I told my client we need to, we weren't going to get anything under the administrative law judge's decision. I thought they were wrong. We definitely need to appeal this. So I'm the one who appealed it to the workers' comp board. And then when we won there, the other side took it up. And sometimes my clients have a hard time understanding. Now in the Spillman case, the surviving spouse was aware of the situation. She understood the law from that standpoint, so she knew they could take it up, and there wasn't an issue there. But sometimes it's hard to explain to someone that, especially when the defendants keep appealing a favorable decision from the judge, which I've had done several times. And in fact, one of my cases at the Supreme Court now is that we won everything I asked for at the administrative law judge level. They took it up to the workers' comp board. The workers' comp board agreed that the administrative law judge decided the case the way correctly under the law. Uh, they appealed that up to the Court of Appeals, basically making the exact same arguments that they made to the workers' comp board. The Court of Appeals said the administrative law judge did exactly what they were supposed to do under the law. They decided the case correctly under the law, applied the law correctly, and then they again appealed it up to the Kentucky Supreme Court, making essentially the exact same arguments. And when you sit and tell the client, yeah, we won in front of the judge, and we won in front of the board, and we won in front of the Court of Appeals, but now we got to wait another year or longer for the Supreme Court to make a decision, and they don't have any money coming in that from that award. Luckily that case the person is back at work, but that's a hard pill for some people to swallow and to understand that they can keep taking it up even though they keep being told that they're wrong.
Especially when they're making the exact same argument.
Yes.
So I'm all for not taking no for an answer, but at some point, it gets a little complicated.
Yes.
But well, Jeff, as we close out this episode, I want to thank you for your time. But seriously, congratulations! You just prevailed at the Kentucky Supreme Court, and you've ultimately helped a tremendous amount of families. Not just your client, Mr. Pittman's client, but ultimately a lot of Kentucky working families here. So well done.
Thank you.
Yeah. Take care. Bye bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.